Hi everyone, we're here talking about the life cycle of a case here at our firm. We've talked to you about the 5 departments in our firm. We really focus on these 5 different departments, which sets us apart because we have specialists in each one of these departments. We have intake and investigation, we have pre-litigation and medical review, we have our litigation department, our probate department, and our administration department. We've talked to you about intake and investigation, pre-litigation, and medical review, and now today I'm going to talk to you about litigation. So really in litigation there are 2 focuses. We file the lawsuit, initiate that action against the defendants, and then we start building the case through discovery. So litigation starts when we file a lawsuit. That is after we've gathered all of the information about the corporate entities who are responsible for what happened in the nursing home and the incidents that occurred that brought you to our firm. So during that process, we make sure that we have found the parent company, the management company, and any other entities that provide any guidance or procedures to the nursing home that are really supposed to be there to keep your loved ones safe. So once a lawsuit's filed, the defendants will either answer the lawsuit, which is where they officially come into court to respond to the allegations, or they challenge those allegations and we litigate those allegations initially. After the defendant answers the case or files a responsive pleading to our complaint or petition, we start building your case through what we call discovery. Discovery is where we gather documents from the other side, gather documents from third parties, and also where we take depositions or interview witnesses to hear exactly what is going to be said on your behalf, on our client's behalf, on the entity's behalf. So some of the things that we do during discovery are guided based on our internal timelines. So there are delays sometimes during discovery, but our internal deadlines are geared towards moving the case forward as quickly as possible so that we have that evidence and a trial date, which really puts us on track to being able to get your case resolved as soon as possible. But sometimes the defendants decide not to give us the evidence that they're required to under the law, and that requires us to file motions to compel. A motion to compel really is a process where we tell the judge that the defendant is not following the laws set forth in the discovery statutes to provide the evidence that's required to prove a case. So if those motions are filed, then we go before the court and argue before the court so that we can get that evidence to prove your case. Sometimes that delays things and sets us on a little bit of a different track, but through the motions, the defendants are required to give us the evidence that's required to prove the case. So once we have gathered that evidence, we can move forward to either settlement negotiations or to trial. Every single case here at SmithKline is worked up as if it's going to trial. We've provided some additional videos on settlement, mediation, arbitration, and trial. If you want some more information on those aspects of the case, please tune into those videos. We appreciate you listening today. We hope this has been helpful so that you know what to expect during the litigation process and when you're working with our litigation team. We'll talk to you next time. Thanks so much.